Unfortunately, I'm not the speaker. I'm just the opener, so
Sure.
I'll try my best, though. Good evening. Welcome. Oh, how about starting on time, like 6 sharp, right? That's what we do. Welcome to the 2026 Lerude First Amendment Distinguished Lecturer Forum. This event is presented by the Reynolds School of Journalism with support from the Lerude Family Endowment. I'm Gi Yoon, the Dean of the Reynolds School of Journalism. The Reynolds School has championed and defended the First Amendment for more than a century. And while we've hosted many programs in that spirit, tonight's Distinguished Lecturer Forum is a meaningful continuation of that tradition, thanks to the vision and generosity of Warren and Janet Lerude. While Warren needs no introduction, Warren Lerude is an alumnus and professor emeritus at the Reynolds School, where for nearly 30 years he taught First Amendment and society, media law, and ethics, and guided professional internships for many students. In 1977, as editor of Reno Evening Gazette and Nevada State Journal, he led a team of 3 editorial writers to win the Pulitzer Prize in journalism. He also guided one of the nation's strongest confidential source reporter shield laws through the Nevada legislature. His crucial contribution to press freedom in Nevada and the nation is invaluable, more so now. Warren and his wife, Janet, met on this campus over 60 years ago. I think about 65, but I'm shrinking it to 60, right? So over 60 years ago, while Warren was the Sagebrush editor and Janet was a song leader. Support for the First Amendment and the free flow of news and public information has been the common thread they've shared since then. Thanks to their support of these initiatives, we're all here tonight to hear from the lecturer about critically important issues our democracy is facing today. Thank you, Warren and Janet. Thank you. Tonight, we are privileged to welcome one of our nation's preeminent defenders of the First Amendment, Charles Tobin, as a leader in Ballard Spahr Media Practice Group. Mr. Tobin has spent over 3 decades at the front line of our democracy. If you have read a headline from the New York Times, watched the report on CNN, or followed the deep dive by ProPublica, you have seen in the result of his practice. His courtroom experience is practically a roadmap of a recent American history. From the Bush-Gore recount, you remember Bush-Gore recount? Right? And the event of 9/11, to the historic litigation surrounding the January 6th Capitol riot and the COVID-19 health emergency, he has defended the public's right to know in more than a half of the states and nation. A former reporter and former in-house counsel at the media group Gannett, he understands the newsroom as well as he understands the courtroom. Please join me in giving a warm welcome to Mr. Charles Tobin.
Thank you. Dean Lerude, Dean Yoon, thank you for that kind introduction, and more largely, thank you for hosting today's events. I spent the day with my colleague, Colleen McCarty, a Ballard Spahr lawyer from Las Vegas. I spent the day teaching classes, talking with students, and just generally absorbing the community that is the wonderful Reynolds School of Journalism. And so a credit to you and to the wonderful organization that you lead. So thank you. I want to give a special thank you to my old friend Caesar Andrews, Professor Andrews. We served together at the Gannett Company, where I was in-house counsel, and he was one of the lead editors for the newspaper chain. Caesar was the reason I understand that I am here today. He suggested my name to the committee, so this is all your fault, my friend. Appreciate you very much. And of course, a special shout out and thank you to our dear benefactors and hosts, Warren and Janet Lerude. You two have been very kind to sponsor these events, to host us here. Wonderful conversation with Warren last night at dinner. And, you know, it's just been delightful for me to learn that, you know, the First Amendment is not only your priority, but it's actually your family's love language. Because not only have you been such an important part of the spirit of the Reynolds and the history of the Reynolds School of Journalism, but you've actually passed those lessons on to your children and their spouses who are here today. And so welcome and thank you to Dan and Leslie, and thank you as well to Eric and Stephanie very much. You all are a very special family in both the history of the school and in keeping the First Amendment safe in this country. So thank you. So friends, we often hear that past is prologue, that history repeats itself, that everything old is new again. Sadly, we're being reminded of those quaint aphorisms as we watch the rockiest time in our history of the First Amendment since the democracy was founded, and we're watching it unfold in each day's news. Yes, we're living in a time of unprecedented government smackdown on the First Amendment freedoms, and it is no exaggeration to say that at least in my lifetime, we've not seen a greater threat to America's free thinkers, speakers, and writers than we are facing right now from our own federal government. We have seen something like this before, kinda, sorta. From time to time in our history, other presidents have tried to clamp down on our First Amendment freedoms and the rights of dissent, along with the right to vote, which always should be and must remain the very foundation of our open society. And so just to remind us of a few historical examples that we have seen this movie before, kinda, sort of, there was the administration of John Adams, our second president, with his Federalist Congress and him being a Federalist president, hauntingly reminiscent, they controlled the very seat of power in our federal government. And so in 1798, the Alien and Sedition Act easily sailed through Congress and was signed by President Adams, and that made it a criminal offense to print, utter, or publish any, quote, false, scandalous, and malicious writings, close quote, against the government or government officials. In other hauntingly familiar language, that language actually sounds very familiar from the day's news and from the politicians we're hearing in Washington. In other hauntingly familiar language, the law also declared non-citizens of the United States to be, quote, dangerous to the peace and the safety of the United States of America. And so, again, much like today, the Federalists in control of Congress and in control of the White House, they used the law to deem anyone who deemed to disagree with their policies and anyone who spoke out against them as the enemies of the people. Again, hauntingly familiar rhetoric. And a dozen journalists under the Adams administration were actually sent to jail in the interval of 1798 to 1800. One famous trial was Virginia publisher James Callender. He later even became more famous because he's the one who exposed Alexander Hamilton's affair and Thomas Jefferson's siring of children with Sally Hemings. But before all of that, James Callender was a critic of George Washington and John Adams' trade policies with Great Britain. That trial under the Alien and Sedition Act was presided over by a Supreme Court Justice, Samuel Chase, and he sent James Callender to jail. Well, the very next president, elected in 1800, Democrat-Republican Thomas Jefferson, freed and pardoned these progenitors of watchdog journalism and government accountability. And in fact, the House of Representatives then voted to impeach Justice Chase. He was not convicted in the Senate. He served out his time. Now, this may sound like ancient history to you, but bear in mind that within this past year, the Trump administration has invoked portions of that 1798 law to justify the increasing intervention in Venezuela and the unprecedented massive deportation of immigrants from this country. Everything old is new again, folks. Suddenly, a new administration has breathed life into a 230-year-old law that most historians thought of as dangerous and thankfully dead doctrine. Then there was Abraham Lincoln, who we all revere for good and valid reasons, but in 1861, he suspended the writ of habeas corpus, which is a constitutional right to petition courts to release you if you were being held unjustly and unlawfully. He even empowered, he not only repealed it, but as the wartime commander-in-chief, he empowered local military commanders in the North and in the advancing armies in the South to jail dissenters who spoke out against the government's activities. And there were Confederate sympathizers and journalists in the North who felt that the war, for one reason or another, was misguided. Well, there was a man named Roger Merriman from Baltimore. He was not a journalist, he was a soldier, but we credit him with being the only person to raise a significant court challenge to the writ of habeas corpus suspension. He was jailed by the commander in Lincoln's army in Baltimore in 1861, and he was jailed in a bit of historical irony in Fort McHenry, Baltimore. Fort McHenry, as we all learned in grammar school, is where Francis Scott Key watched the British shell in 1814 in the War of 1812, and thus we have the Star-Spangled Banner, which was inspired by that shelling. Well, Merriman brought a court challenge to his confinement, and that led to a decision by then Chief Justice Roger Taney. We lawyers call that decision ex parte Merriman. And that decision stands for the proposition that only Congress can suspend civil liberties during wartime. Again, very reminiscent of the pull and tug we're now having, even on a somewhat bipartisan basis, between what President Trump and the Congress. The words in Justice Taney's ruling have haunting resonance for today, when the streets of my hometown, Washington, D.C., and many other American cities are seeing military patrols as a matter of commonplace in our cities. I drive over the Memorial Bridge. It's very inspiring. I see the Lincoln Memorial every day on my way to the office. It never gets old, folks. But I also now see National Guard troops patrolling in groups of 6 or 8 or 10 around the streets of Washington, D.C. Chief Justice Taney told the White House in that historic decision, quote, "I can only say that if the authority under the Constitution may be usurped by the military power at its discretion, the people of the United States are no longer living under a government of laws." Everything old is new again, friends. More recently, we know that in the early 1970s, a couple of Nixon White House aides, Howard Hunt and G. Gordon Liddy, a pair of his most lawless assistants, proposed that the Nixon administration kill investigative reporter Jack Anderson. For some folks in this room, Jack Anderson is a hero, an icon of progenitor American investigative watchdog journalism from the 50s, 60s, 70s, and on. I'll join you in an applause for the late Jack Anderson and for investigative journalists everywhere. Absolutely. That Pulitzer Prize winner was really good at reporting leaks from the Nixon White House, and the president formed what was so-called the plumbers unit to plug those leaks. And Hunt and Liddy were sitting around and spitballing one day in the White House various ways to do their job. One suggestion they seriously considered was substituting Anderson's medication, breaking into his apartment, going into his medicine cabinet, and substituting it with poison. Another one, suggested by Liddy, was to smear massive amounts of LSD on his car's steering wheel, hoping he would have a hallucinogenic fatal accident. None of that came to pass when the Watergate issue became exposed. All of that activity thankfully stopped. But if you go to the National Archives website and listen to the Nixon tapes, you will hear the Attorney General, John Mitchell, comment that they ought to brand Anderson a traitor and hang him. Nixon responded, quote, "God damn it, so listen, the day after the election, win or lose, we've got to do something about that son of a bitch." Everything old is new again, folks. And even more recently, during the George W. Bush administration, and I actually went to the courtroom to watch this history unfold, even though I was not part of the case. A federal judge instructed a marshal to handcuff then New York Times reporter Judy Miller and to take her away. They actually had her take off her jewelry with her hand shaking and give it to her husband. It was a very disturbing and poignant moment. Well, what did Judy do? She reported on an anonymous source who had said, follow me for a minute, folks, that an ambassador who had criticized the war effort in Afghanistan and said that there was no yellow cake in in Iraq. There was no yellow cake in Iraq, a part of the building block of uranium, building block of nuclear bombs. This ambassador, based on the intel he had done, was convinced that the Bush administration was lying about it. His wife was a woman named Valerie Plame. A lot of people in this room will recognize Valerie's name. Well, that source told Judy Miller that Valerie Plame, the ambassador's wife, the critic of the White House's wife, was a covert CIA agent. He instantly blew her cover, and he committed a grave national security leak. Judy refused to reveal who her source was, and for that she was sentenced to contempt. She refused to a grand jury, and she spent better part of a month and a half in lockup over that. The leaker in that circumstance later came forward 75 days later, and it was none other than Scooter Libby, who was Vice President Dick Cheney's chief of staff. And so the White House propagated the information that blew the cover, or at least Scooter Libby did, part of the White House administration, that outed a CIA agent, and he did that in retaliation, obviously, for the ambassador's courageous speech. So yes, my friends, these are very disturbing anecdotes in our collective past, and we should never, ever forget what other presidents have done. But the Trump administration makes all of this dreadful history feel like quaint detours on its path, its vision of what the First Amendment should and should not be in this country. And that vision, I will submit to you, is so dangerous for our country. Never before have we had a federal government who has treated the denigration of the right of dissent as a key policy priority for the administration. And that is no exaggeration. We are witnessing the calculated, aggressive government erosion of our First Amendment freedoms for the news media and for every one of you and for every one of us. So please hear me. Every generation in this room, everyone watching online, we must work together to find ways to prevent this further erosion of our fundamental freedoms for us and, significantly, since we're on a college campus, for the generations of people and Americans to come. In a few minutes, I'll make some constructive suggestions for each of us as to how we might do that. And again, there is no better place to generate these ideas and to have this discussion under our First Amendment. There is no greater bulwark for freedom of expression than journalism schools in the United States. And there is no greater journalism school to have this conversation than the Reynolds School of Journalism. And so these are discussions that we must have as an incubator in our campuses of the future of the First Amendment and of the basic freedoms that make us Americans. So what is this administration's dark vision for the First Amendment? Well, I am privileged to work with a few dozen of the smartest, hardest working First Amendment lawyers in the country. Those would be the media lawyers at my law firm, Ballard Spahr. And we have talented media lawyers all over the country, including right here in Nevada. We represent all of the legacy and new media newsrooms in the United States, all of the brand names that you consume news from or that you have consumed news from. We are so fortunate and so privileged to be their lawyers. As I mentioned, one of the members of our team is sitting right here, my good friend and colleague, Colleen McCarty. Colleen is in our Las Vegas office. She's a former television reporter herself. We've been having lots of great conversations about journalism as a path to law for those who are interested or sufficiently motivated. I'll speak in a minute. I'm going to give a plug, Colleen, to the wonderful work that you're doing right now, about the excellent work that she's embarking on here in Nevada. But with serious concerns for our beloved clients right after the 2024 election, our lawyers huddled together to compile a list. We did this in December of 2024, right after the election. I convened a meeting because I wanted to talk about the work that we knew had to have been done by President Trump's supporters in the 4 years that he was out of office. We had seen Project 2025. Project 2025, we knew would be the blueprint for a new, it was the president's vision for a new society. He denied it, but we're now seeing it unfold exactly as it was in that document. And we were certain that he and his advisors in those 4 years had crafted some kind of a plan to give more structure to the notion that they had poisoned in the American bloodstream of a fake news media in our country. We knew that they must have crafted a plan, and it had to include a press that was no longer free and that felt chilled by the very government that's supposed to protect it. So we wanted to prepare ourselves, and we wanted to prepare our clients for the adversity that we knew was headed our way. And I'm sorry to say that in just the 14 months since the inauguration, we have already seen every one of those perils for the free press, perils for all Americans, already come to pass. As I said, make no mistake, friends, there is now a concerted federal government policy to contain, restrain, and force the press to report only on the official point of view. So let's review what we just knew was going to happen and what this administration would do. And when we finish, let's talk about some things we might do together to try and preserve some of our essential freedoms. So we knew that this White House would immediately curtail journalists' access to government offices. In February 2025, just 1 month into his term, President Trump threw the Associated Press out of the Oval Office press pool. The AP actually started the concept of a press pool back in 1887 when President Garfield was shot. An AP journalist sat outside of the room where he was being taken care of by his doctors, listening as he slipped away, and he would then go share his notes with the other journalists who covered the Capitol at that time. The AP, I would say, because of that storied history and because of its continued dedication to fact-based truth-telling, remains one of the world's most respected, nonpartisan newsrooms. One of my favorite quotes in journalism history is Mark Twain's. He is quoted to have said, quote, "There are only two forces that can carry light to all corners of the globe, and only two, the sun in the heavens and the Associated Press down here." So what was the AP's transgression in 2025 in the eyes of the president? Well, they adhered to the name Gulf of Mexico in the face of an executive order by the president renaming that body the Gulf of America. Well, the AP style book does note the president's EO currently, but in their broad discretion allowed to them under the Constitution, the AP made the considered decision to retain the name Gulf of Mexico. And they've spoken out and written about why that is. Gulf of Mexico is not completely within the territory of the United States. President Trump reverted to the name Mount McKinley for Denali in Alaska. That is within the territorial confines of the United States. The AP now refers to that mountain as Mount McKinley. But the AP made the decision that the 400-year-old historic name was more accurately described as the Gulf of Mexico. And for that, its photographer and its text reporter were ejected from the White House press pool. My law firm and I are privileged to represent the AP in that litigation, and I was proud to hear while I was here that the Reynolds School honored Anna Johnson, who's the bureau chief of the AP, for that very case just last week. It is noteworthy and it is praiseworthy that the AP has stood up in this case. And as I argued in the court, I should tell you, we won an injunction, a 40-page injunction. Go look for it. It is a wonderful piece of First Amendment jurisprudence that stands for the proposition that a government cannot discriminate against people because of their point of view. They cannot take away a right or benefit or a privilege. They cannot punish you and they cannot banish you simply for your point of view. Well, as I argued in the Court of Appeals, our central issue in the case is the right of all citizens to be free from that kind of retaliation by the government for exercising their First Amendment rights. If you go find the appellate argument on the D.C. Circuit's website, Court of Appeals for the D.C. Circuit Federal Court, the central issue President Trump's lawyer articulated from the Department of Justice, and it was very blunt, he was very candid about it, is the president's right to eject anybody from the White House when he does not like their speech. He was asked very directly by the court, is that your position? And he said, yes, that is the White House is the president's position. Well, Americans should never stand by while the president barricades the Oval Office from the freedoms of the First Amendment, and journalists should never stand by and let the government coerce how they report the news. That is their constitutional right. So just 6 months after the president's edict against the AP, the Pentagon Press Corps walked out of that building. They have been covering the Pentagon since 1943 as a press corps with an established office there for the Corps. In near total solidarity, the journalists refused to sign onto new rules to refrain its reporting and to have it promise not to report anything but officially released information. Importantly as well, the new Pentagon rules of engagement with the press require them to acknowledge that reporting information other than through official channels would harm the national interest. Well, that statement we know from our history is flatly incorrect. From the reporting on the Pentagon Papers, which was a leak, which showed that that the Nixon administration was lying about the casualty count in Vietnam, to more recent reporting about the Secretary of Defense casually texting war plans on an unsecured channel and looping in by accident a journalist. The ongoing news that began with the joint U.S.-Israeli military action against Iran and is now vigorously being debated in our society and in Congress should be an example of why military affairs so desperately need the scrutiny of an independent press, not a pool of journalists who will only agree to reports fed to them by this administration or any administration. A group of talented lawyers at another firm, Gibson Dunn, I'll give my colleagues at Gibson a shout out, are currently suing on behalf of the New York Times to overturn that banishment. We wish them very, very well. We knew that this administration would slow walk FOIA, Freedom of Information Act requests. To be honest, FOIA has never been a tool for real-time news reporting. It should work that way, but it does not. So I began practicing law during the George H.W. Bush administration. And despite many promises and a congressional amendment to the Freedom of Information Act, I have to tell you, no president has made transparency of government records a serious national priority, even though there is a law that says that they must, just like there is a law that says every other thing that the government is obligated to do. It is not on lesser footing than anything else that Congress has ordered is the law of the land. And in fact, from the Bushes through Obama, through Biden, I saw no appreciable difference in how executive agencies treated their legal obligations. They all delay, slow walk, stand on thin legal arguments in court, and release pages and pages of heavily redacted documents. All of this despite that federal law that requires the release of documents within 20 days. It allows you a little more time for really complicated requests, but that's the default, that's the law. Well, it took my Ballard Spahr colleagues and I years to win the release of the Mueller report on Russia's involvement in the 2020 election, FBI Director James Comey's memos on those very uncomfortable meetings he had with President Trump, where according to his memos, the president demanded his loyalty. The Department of Defense Special Inspector General's report on fraud, waste, and abuse in the contracts awarded to companies to rebuild the infrastructure in Afghanistan. The millions in fraudulent claims in the awards of small business loans during the COVID lockdown. The terabytes of January 6 riot video that the House leadership released only to select journalists like Tucker Carlson. It has taken us years to succeed in that litigation. But this administration is next level obstruction. One example, despite his promise of radical transparency, Health and Human Services Secretary RFK Jr. almost immediately fired the entire FOIA staff at the CDC, the Food and Drug Administration, and the National Institutes for Health. Agencies like OSHA, which is supposed to keep our workplaces, monitor the regulations that keep our workers safe in America, started sending out email responses when you emailed your FOIA requests that read, "Hello, the FOIA office has been placed on administrative leave and is unable to respond to any email." How do you even get in the pipeline to get your records if they have closed the gates and shut off the valve right at the start? We knew that the White House would enlist federal agencies to coerce expression. We've already seen the Federal Communications Commission pressure a network to take a late-night host temporarily off the air for his remarks after Charlie Kirk's murder. Chairman Carr of the FCC has announced a new interpretation of the equal time rule to micromanage guests, political guests, for late-night talk shows and even The View. And President Trump posts regularly on Truth Social which media mergers he likes and which ones he does not, a non-subtle message to regulators. We also knew that this administration would raid journalists' files. To be perfectly fair, the Trump administration actually is not the first one to obtain a warrant or a subpoena against a journalist. President Obama's DOJ secretly obtained a warrant for a Fox reporter's Gmail account while they were investigating a leak from the State Department. The Biden administration subpoenaed the phone records of a Guardian reporter trying to uncover leaks from DHS. But in both cases, when those subpoenas came to light, the administrations apologized and immediately started inviting the media in to say, "We messed up, we want to do better, we want you to be a part of that conversation." And so both Attorney General Eric Holder under Obama and Attorney General Garland under Biden invited the working press and their lawyers into DOJ headquarters to have a conversation about what can we reasonably do to retain the needs of law enforcement to investigate the sanctity of government, high national security interests, and to respect the First Amendment rights of journalists. I actually had the privilege of sitting in on one of those meetings with Attorney General Holder. Those meetings led to new rules each time that crafted a balance between extensive internal review at the agency, exhaustion of every other possible source of information, the approval of the Attorney General himself, the very highest people. They have to have a deliberate, had to have under those regs, a deliberate and detailed discussion, and they had to reach out to the newsroom in all but the most extreme circumstances to have a conversation with the newsroom about the information that they were seeking before they ever asked a judge to issue a warrant or a subpoena. This White House repealed all of that work, and it has upped its subpoena game with brute force. They have passed a new set of regulations. It does, if you read it, sound very First Amendment friendly, but just look at how it's been played out. On January 14 of this year, the FBI raided the suburban home of Washington Post reporter Hannah Nathanson. DOJ had already indicted the government contractor that they thought was leaking information to the Post. And despite already having charged him, the DOJ and the FBI seized the reporter's 2 phones, 2 laptops, her Garmin watch, a portable hard drive, and a recording device. Now, of course, that reporter has a lot more source information on those devices than anything that may be related to the reporting that the government was interested in. And we still don't know why this raid was actually really necessary for the successful prosecution of somebody who, if they broke the law as a government contractor or a government employee, they broke the law, and the court system should work that out. Well, a federal judge has actually already dressed the Department of Justice down in open court for not providing him with full information before he agreed and issued that search warrant. And he essentially has told the FBI that instead of going through the information that they seized themselves, they have to leave it unlocked, they have to maintain the status quo. And the judge himself said, I will go through the information and I will decide. He didn't say this, I don't think, directly, but clearly he no longer trusted the process, the government, to do an honest job itself. So we also knew that this administration would arrest journalists. And so Don Lemon and Georgia Fort, both bona fide decorated journalists, were covering the protests against ICE activities in the Twin Cities, doing what journalists get paid to do. They were following the protesters around with cameras trained on the protesters and on ICE. They followed the protesters into a St. Paul church. After the story, ICE asked 2 federal judges to issue arrest warrants. Each of those judges found no probable cause that the journalists had committed any crime, and they refused. So rather than focus on investigating the murders of protesters Alex Priddy and Renee Good, our Justice Department went to a grand jury, another mechanism to secure an arrest warrant. And so they obtained the indictments that they wanted, and now the journalists stand charged with a crime of interfering with access to a house of worship. It's an interesting historical irony that that particular law actually was started as a bill to permit the access, the unfettered access, guarantee women unfettered access to abortion clinics. And then they put on it, and as well, not interfering with religious freedoms, with your right to worship. And so these 2 journalists now stand accused of those crimes, and they had to lawyer up, and they will have to go through the process. I want to give a shout out while we're in Minneapolis at the moment to my colleagues Lita Walker and Isabella Nascimento, 2 fabulous lawyers in our law firm's Minneapolis office. Isabella and Lita are out on the streets. They have literally been keeping a protective eye out for journalists and keeping a wary eye out on ICE and making sure that if any journalist on the street needs a lawyer or any of our clients need help to get access to the streets or have interdiction issues with ICE, they have good counsel to help them. And so shout out and great work, Lita and Isabella. And we knew this president would file defamation cases to coerce newsrooms. President Trump has always bragged as a businessman about using the courts not to redress genuine injury, which is what the courts are there for, but as leverage, as a business tool. I had defended a broadcaster's defamation lawsuit brought by the Trump campaign in 2019 from an opposition ad. Clearly, the leverage there was, we'll sue you and try and chill you to keep that ad off the air. The broadcaster had us fight it vigorously, and President Trump, it was the Trump campaign who was the plaintiff in the case. They dropped the lawsuit after he lost the 2020 election. But you know, he's not daunted. He's not easily daunted, as we know. And so where are we now? Well, this sitting president has sued CNN, the Wall Street Journal, the New York Times, the Pulitzer Prize Committee, ABC, CBS, and the BBC. And in all of these cases, the goal of President Trump's lawfare is crystal clear. Chill unflattering coverage by tying up the precious resources of an industry that is always strapped for cash. The courts will work those issues out, and they will decide, is President Trump right or is the news media right? So friends, in a little more than a year, President Trump has made the speech-chilling efforts of prior presidencies, Adams, Lincoln, Nixon, look like a First Amendment fan club. Now, we could sit passively by in despair as we watch the First Amendment assaulted as a matter of federal policy each and every day, but I am confident that decent, hardworking, freedom-loving journalism students and the faculty, folks in this room, and the alumni, and the people who just care, and I'm enlisting everyone online out there. You're part of this discussion as well. We want your help to turn the tide, or at least push back against further erosion. So you sit there and you say, how can I do that? I'm just one person. So here are some thoughts. First and foremost, respect and support local journalism. News deserts are sadly stretching across large swaths of the United States. County and city commissions are going unwatched. Local police departments are no longer nearly as accountable as they should be. Municipal FOIA officers and offices are ignoring requests. Local journalism matters if we're going to force governments to be accountable for the decisions they make. Local journalism matters a lot. So buy subscriptions to your local news sources, feed them with tips, get to know their news teams, start your own news organization to cover your community. Encourage local journalists to keep doing what we need them to do. Special message to this group, the students who are here or watching online. Go out and report the stories now that need coverage. You have wonderful outlets at this university, KUNR, the Sagebrush, and others that I'm not yet familiar with. You have the outlets, you have the tools, and you have wonderful mentors and supporters in this community. Let's go out and help irrigate these deserts with solid student watchdog coverage. Respect and support the independence of judges. Some historical examples I've already cited. The entire legacy of our First Amendment freedoms since the 1964 landmark decision of New York Times versus Sullivan, recent court decisions in the new Trump administration. A lot of that should teach us that we need a strong, independent judicial hand in this country. And for all the discussions about Trump judges, Obama judges, Biden judges, Bush judges, as a lawyer, I will tell you what I need most is a well-written brief showing the judge a clear legal path to support what is solid journalism. Bring me a solid story. Bring me a story that is lawful and within your First Amendment rights. I'll take my chances with and bring me talented colleagues to help me craft an argument, and I will stand proudly and take my chances with any judge, regardless of which politician appointed them. How do you support the independent judiciary in your roles? I would say if you cover the courts, and you should cover the heck out of them, do it fairly, accurately, make sure you understand where the judge is coming from, regardless of what she says from the bench or what kind of legalese is in a court decision. Understand it and translate it to your audience, and you will have the respect of that judge, and it will become part of the symbiotic relationship that the Fourth Estate has with the first three branches of government. How do you do that in your role as American citizens? Obviously, vote, participate in the electoral process, canvass, get out there and get involved. If you're unhappy with the decisions coming from appointed courts, if you think they're based on politics and not the law and the facts, lean into the way your judges are appointed and persuade others that they need to do the same. Respect and be aware that when you gather the news, the government may be watching you. And so we are increasingly counseling our newsroom clients to return to those Woodward and Bernstein days of putting a pot on your ledge so that the source knows that you're ready to meet with them, and meeting them in garages in Roslyn, Virginia, and the like. We counsel clients now to use air-gapped computers to review digital materials that they receive, to separate their work and their personal devices, to move across international borders with clean machines, to make sure that the newsroom has adequate insurance coverage against defamation threats. I cannot stress that important thing enough. One of the first questions I will ask when I get called by a client is, who is your insurer? What is your deductible? What is your coverage limits? Because it's a very important part of protecting your newsroom from those who would try and do it harm. And if you're covering a conflict area, make sure people know where you are. Your newsroom should provide you as well, and I suggest on paper, because devices get seized, with a cell phone number for a lawyer or two or three who can come help you if you get caught up in an ICE arrest situation. Finally, Respect and demand transparency from the officials who govern us. My colleague Colleen over there was just appointed to a government transparency task force created in the last Nevada legislative session. We're very proud that she, along with our friend Ben Lippman, who is the general counsel to the Las Vegas Review-Journal, will work on a panel with lawmakers, municipal clerks, and representatives of the state's media. Their charter is to evaluate the exemptions in the law, to measure the impact that broad requests have on the government and how government can be better at fulfilling requests more efficiently, more economically. The cost being charged to citizens for public records, that's kind of become a new thing of how to deny a request, is just by charging an exorbitant amount of money. And streamlining methods to resolve disputes so that we're not tied up for years in courts before we get the records when they're no longer even newsworthy. I urge all of you to follow Colleen and the committee's work. More broadly, go to public meetings of your local governments. Do not let them shut you out or shut you up. Request records, stay on top of statutory deadlines for their responses. And when you don't get what you're entitled to, post about it, blog about it, broadcast about it, and let's sue about it. Now, despite the gloomy times in which we find ourselves with 10 years of propaganda about fake news washing over us and poisoning the bloodstream of the American zeitgeist, and with another 3 years left in the administration's blatantly anti-First Amendment playbook, I still remain a free speech optimist. I really do. Newsrooms are transforming as consumer habits changed, and unlike dinosaurs, I happen to think that's terrific. I had some wonderful conversations with journalists, and I know among the group out there is a Pulitzer Prize winner in the making. We're going to get some great work out of the folks and great American citizenship out of the folks coming out of these journalism colleges. In my own college years, drawing on my own example, USA Today launched to a chorus of doubters who worried that its concise storytelling format would kill journalism as we know it, kill any thoughtful journalism. Well, decades later, the newspaper and its network of news partners have pulled in a number of Pulitzer Prizes, including, of all timely topics, the 2018 award for the coverage of drug trafficking across the border and the Trump administration's efforts to stop it. The parent company of the so-called McPaper Gannett is and was the home to professionals who are still making their mark on journalism, like Professor Lerude, like Professor Andrews, and like myself. I really cherish the years that I had as an in-house lawyer. I really learned my craft, and I learned to respect the role of journalists in society during those years. The increasing power of connectivity across the web, the interesting and diverse platforms emerging to host important news reporting, and the yet untapped potential for AI. We don't really understand yet how it can help us or what it can do. I remain an optimist that we will find constructive and useful ways to contribute to society through AI. Let's make these the tools that save journalism for the rest of the for the rest of the century and beyond. And journalism programs are still thankfully turning out young, hungry, intrepid reporters. I'll again draw from a personal example. My own son, Ben, came out of the University of Virginia and had been the managing editor of their excellent newspaper, the Cavalier Daily. Ben went on to take a job at the Louisville Courier-Journal, a Gannett newspaper, and in his very first year, he was the leader of the team that won the Pulitzer at the Courier-Journal. He helped break the very first stories that galvanized the newsroom's entire week of coverage. Ben and his colleagues found out that the outgoing governor, Matt Bevin, who had been defeated by Andy Beshear in an election, in the waning days of his administration, was sitting in his office signing pardons to the children, the family members of donors who had committed and been convicted of violent crimes. And he was doing that to the anger, the consternation of a cadre of prosecutors. He was a Republican. The prosecutors were Republicans. They were not happy to see their hard work and these people walk out of prisons because of a gubernatorial pardon. And for that energetic week in the newsroom, the newspaper and my son Ben shared the 2020 Pulitzer Prize for breaking news reporting. Thank you. As a speaker and a father, thank you. Ben and other hungry journalists give the people hope, give me hope. I come away from this engagement today with so much hope for journalism and for our future. We are raising the emerging generations of eager, skillful, determined journalists, and they are going to do as well as each and every one of us. We will be as proud of them as we are looking back on our own careers and our own contributions. And so with the guidance of caring, experienced faculty right here at the Reynolds College of Journalism, with the focused application of new technologies in the newsrooms, and with the determination to keep shining those bright lights in the dark corners that really, really need illumination, we will, as my First Amendment hero, the late Justice William Brennan said, we will remain committed to uninhibited, robust, and wide-open debate and free American thought. Thank you very much for the privilege of being here today.
Thank you, Mr. Tobin. Now we will have our own Associate Professor of Media Law, Patrick File. Professor File will lead the discussion as well as Q&A after the discussion.
Yes, we're hot.
Hot mic.
Yes, well, thanks, of course, for that wonderful talk. And I've got a couple of questions for you. It was such a broad and sweeping look at a lot of what's going on, so I think hopefully with a couple of these questions we can dig a little bit deeper on a couple of particular issues.
Great.
And then, of course, get to what I think we always agree is the best part, which is the audience Q&A of this event. So one of the things you briefly mentioned in kind of talking about some of these, the ways in which firms like yours and others are working on sort of forcing some accountability and some transparency. You mentioned work around the January 6th, sort of the prosecution and then the sort of, unprosecution, of the folks that were pardoned as a part of that. And I wonder if you could kind of get a little bit into that a little bit more, because I do think it's a particular instance that's sort of happened a little bit behind the headlines, and maybe sort of the information that was made available to journalists and then thus to the public was an important part of that, but maybe what was happening legally behind the scenes is a little bit less well known.
Delighted to, and I'll give a shout out. Professor Lerude actually wrote about this anecdote I'm about to tell you in his online column, commended to your reading. So in March of 2021, just a couple of months after the January 6th insurrection, CNN called me, a regular client of ours. We do a lot of work with the brave journalists at CNN, that a man had been grabbed up and arrested in West Virginia for participating in the riot. And he had been, when you pulled in, you have to go before a federal magistrate judge pretty quickly. For a detention hearing, judge has to decide, are you a danger to society, a flight risk, other reasons why you ought to be detained. The Department of Justice rightfully played a lot of video in that hearing to show what this man had done. He was actually one of the bear spray people who had arrived at the Capitol with bear spray. The problem for the journalist was we were in the middle of COVID lockdown. There is no televising of federal court proceedings in the United States. It's verboten when it comes to a criminal case in a federal court. We're trying to change that, our law firm petitioning for a change in the rules. But there were no journalists present in the courtroom. I understand that there was an audio link the federal courts tried to accommodate. At any rate, they wanted the video. They wanted to see what this man was being held up to account for that justified that magistrate judge's decision to make the guy be detained and ultimately transfer him under federal custody to D.C. Ordinarily, court records of any kind that are presented to a judge are public. That's the default, the presumption in the United States. Supreme Court has told us that over and over again. This was a court record. It was nowhere on the docket. And there were a couple of reasons for that. One was the lockdown circumstance, and the other was the federal court system has no mechanism in place to post video like you would a brief that I just filed in one of my cases today. You can get those online. You can't get the video. Just was no process to do that. So we immediately filed a petition for release of that video. We asked for it to be done right away. And pretty quickly, the judge granted, the judge who it was assigned to, transferred to, granted our motion. 2 days later, the same thing happened again, and again, and again. And so we were serially filing these motions, and it ultimately became a coalition of, I think, 20 different newsrooms, 15 to 20. I'm a little fuzzy at the moment on the numbers. CNN, ABC, NBC, the New York Times, the Wall Street Journal, ProPublica, all of them joined in, and we were privileged to represent all of them. After about 6 or so of those, I brought some of the lawyers working on the matter into my office, and I said, you know, we've got to try and front-end this system, because we're going to be doing this for years now, because they're talking about arresting hundreds, if not thousands, of people. And so we petitioned the chief judge in D.C. of the federal court, and we asked her for what we call an administrative order. We asked her to order that any time a detention hearing was held, or any hearing, and video was shown, that a system be created by the Department of Justice to give us access to that video. And we told her that she should order it be done every time. Great judge, Chief Judge Beryl, then Chief Judge Beryl Howell. She didn't completely agree with us and give us everything we wanted. There's something called the Sixth Amendment, which gets in the way. It comes in conflict sometimes with the First Amendment, and it's the defendant's right to a fair trial. And I'm being facetious. It's crucially important. She left it to the individual judges to do the balancing act of our rights to access versus their rights, but she recited the law that presumes that access should be granted in a very full-throated way as guidance to all of the other judges. And then she said that any video a judge ordered must be placed on a website, an FTP, file transfer site, by the U.S. Attorney in D.C. within, I think it was like 72 hours or something like that. And so we just went in motion after motion. Now they became a lot shorter. We just pointed to her administrative order and said, we request the court order to do what the chief judge said. We ran into some resistance from defendants here and there. It's invading my privacy. I'm sorry, you should have thought about that before you attended a riot at the Capitol in front of all cameras, I might add. And not to mention, some of y'all were filming this and pretending to be journalists and all of that. But we won every single one of those challenges. Years later, that led to 3 terabytes of information. When President Trump was reelected, somebody on our team noticed that one of the files, at least one of the files, had gone missing after the pardons, actually, from the FTP website. And so we immediately went to the new chief judge and said, please order them to stop deleting any files and to restore anything that had been deleted. We got that order, I think within a couple of days. Chief Judge Boasberg, another excellent jurist. And so those files were restored. I then became worried, okay, what's going to happen as time goes on? And so we engaged in the process with the Department of Justice, which really wanted to shut down that FTP site for maintenance reasons as much as anything, I think. And we secured a court order with their cooperation, actually, where those terabytes of information were put on a jump drive, portable hard drive, and delivered to my office. We then engaged in a conversation with the Internet Archive, the Wayback Machine, fabulous organization. Not for nothing, they have the best collection of Grateful Dead bootleg tapes anywhere. Highest and best use. We engaged with them. I spoke with their director, and he said, send it to me, let me see what it is, how we can manage it. And on January 6th of this year, they went up on the Internet Archives, so you can now have access to what we believe will be a permanent record now of exactly what went on January 6th.
Great, thank you. Yeah, here, here.
Let me give a shout out, since I'm name dropping, to Lauren Russell and Max Mishkin at Ballard Spahr, young lawyers who stayed at their posts for years with me to make sure we had all of that information.
Yeah, I mean, it's an important, again, when we're dealing with a kind of moment of revising and revisiting, and in some cases deleting history, this is certainly something that is, sort of the video record of what happened is an important part of that.
Yeah, President Trump on January 6th dropped a terribly propagandistic rendition of what happened on January 6th. He blames Nancy Pelosi for it because he says the true insurrection was the theft of the 2020 election. And so we were proud that we had the counterweight drop on the Internet Archives on that very same day.
Yeah. So another thing that you talked about a little bit was defamation law and libel suits as a tool to chill speech. And I wonder if you could talk about that a little bit more, and sort of, especially because I know a lot of your practice has kind of over the long term has been on defamation cases. Something that has been sort of up until relatively recent history, a kind of well-established, understood, principle is the New York Times versus Sullivan decision that you referenced and quoted there in the end, Brennan's words about an uninhibited, robust, and wide open commitment to free speech. That also is a precedent that isn't maybe as etched in stone as we'd like to think. Can you talk a little bit about sort of the U.S. Supreme Court's view maybe evolving, or at least individual justices evolving around that, and kind of maybe what we might need to know about that, and maybe even where you might see that precedent going?
Somebody famously said, reading crystal balls ends you up with a handful of broken glass. So, it's dangerous to read the judicial mind unless they're very clear in their writings. So Justice Clarence Thomas has very clearly, in opinion, dissenting from the Supreme Court, even taking defamation cases. Court has not touched most of the defamation cases, most of those cases. He has dissented in case after case, taking the originalist position that there was no special protection under actual malice at the time of the founding. And in fact, they were criminal. He even raised the fact, is a good thing, looking at history from a historical perspective, as supportive of his view that there were criminal libel laws for libeling public officials back then. And he also argued that when your reputation, when your notoriety is at the highest as a public official, you have the most to lose. And so that there is really no need and should not be any need for special protection from an originalist point of view. Along came Justice Gorsuch in another decision in which he said, media has really changed. He took much more of a fast-forward view. Media has changed. The news media is no longer in a special position where it's the only one giving out information. Now we've got everybody, bloggers and people with cell phones everywhere. And so maybe we should rethink this special actual malice rule, notwithstanding the wonderful rationale in Justice Brennan's decision from 1964. We call Thomas New York Times hostile. We call Gorsuch New York Times curious. And they're both brilliant people. I'm really not denigrating their intellect. I just vehemently disagree with their approach, and I think they undervalue the needs for the special protection, and I call it special. There's nothing special about fundamental rights. They're your rights. But they are the only two so far who have spoken about this. Everybody is watching, Kavanaugh, Justice Kavanaugh, Justice Coney Barrett. There was a decision that came down in a computer stalker case, really creepy case, Counterman versus Colorado. And the decision came down to what type of proof do you need to convict somebody of computer crime versus free speech, which may be icky or offensive, but it's not really criminally prescribable. Justice Coney Barrett actually, in reasoning out in her separate opinion, what she thought cited New York Times versus Sullivan as a subjective standard. And so we read some comfort in that, and ultimately Justice Kagan, I believe, wrote the controlling decision. I think, said a long-winded journey, thank you for going on it with me, to answer your question, I think we're safe on New York Times versus Sullivan, but I could wake up tomorrow with a handful of broken glass.
Sure. And that's, again, what's crucial there is that this is protection for the press, but also any critic of a public official or another otherwise kind of powerful person that sort of sets a high bar for them to be able to successfully sue for defamation. It doesn't stop them from suing for defamation, but it certainly makes it harder to win and hopefully puts kind of the brakes on that kind of a lawsuit. To shift gears, again, in sort of another direction, you talked a little bit about the press corps, the sort of changes on the Pentagon press corps, and the sort of agreement that reporters were expected and news organizations were expected to sign. I think maybe some new urgency around that requirement, and maybe the changes in coverage of the Pentagon now that we are officially at war in Iran and in the Middle East. And so I suppose the question is, how can we think about the implications for coverage of that war under these new standards? Do they not apply when you're kind of in the theater? Would we expect the Pentagon to sort of extend those limitations on non-friendly or objective or impartial reporters, both on the ground as well as back here at the Pentagon? I mean, sort of what can we maybe expect or be concerned about, or with regard to coverage of sort of an active war as opposed to sort of just the Pentagon as a government institution in the meantime?
We're getting kind of mixed signals on that from the administration.
Sure.
President Trump, as I was reading the news yesterday, so forgive me if I'm slightly off on this. My understanding is CNN actually spoke with the White House about current affairs, and he's giving interviews here and there. On the other hand, there's nobody in the Pentagon right now for the ordinary press corps that we're privileged to represent, who are out there actually reporting what's coming out of the different offices at the Pentagon, the different commands, the logistics command, the supply command. And so, I would imagine if you asked a former Pentagon reporter, a defense reporter, they would say that they're losing access to important information, again, at the time when we need it the most. I'm not going to get into the political positioning of whether we should or shouldn't have done what the United States and Israel have just done. But regardless of where you are in the issue, you need the information to be able to have an informed discussion about it, and a lot of those channels are now cut off.
Yeah. I realize I might have left before we pivot to audience Q&A, sort of maybe the most difficult question for the end, but let's try it anyway. I guess there have got to be challenges in providing legal representation for media corporations. Corporations, sort of the focus of that part of the question, which is to say, these are institutions that are often somewhat conservative, risk-averse. When what you're talking about is sort of these, the need to protect access to information, the public good, the First Amendment right to do what journalists do. And I guess, you've been doing this a long time, and I wonder what kind of, whether it was, you could phrase it as advice for a young lawyer, or you could just think about kind of lessons learned where you're dealing with, on the one hand, reporters who need help and need access and need, kind of support, where also you're dealing with, corporate entities that are risk averse and are maybe more willing, or let's say less willing, to spend the money or the time or the resources to defend certain cases or defend certain circumstances. And I guess, how does one navigate that a little bit? You're kind of advocating both for the First Amendment as well as for your client in some circumstances, and those aren't always necessarily, I have to imagine, kind of completely in line with each other.
First and foremost, as a lawyer, I advocate for the position that my client has decided is in their best interest, whether it's, fight to the hilt or try and find another path. So my job as a lawyer is to just make sure that once the client decides on what a win looks like for them, my job is to get out there and try and make it happen for them. I think it's perfectly legitimate for journalists to debate, to rage, to discuss what's going on in the C-suite with management. Heck, we did that when I was a reporter down in Fort Myers with sand under my shoes from going from beach community to beach community to find out what the news of the day was there. We never thought we had enough equipment. We never thought that the company gave us, computers were just coming around then. We only had one for the particular office I was in. We wanted a bunch of them. These debates have always been happening between journalists and management in newsrooms. It's a healthy part of the process. I just hope at the end of the day, journalism survives and the journalists feel like they can continue to do their jobs.
Okay, thanks. We have a couple of microphones floating around, and so now we get to hear what you're wondering about and what your questions are for Chuck. And we do ask that you wait for a microphone to come to you since we're live streaming, and that's sort of the best way that we can make sure that everybody hears your question. Looks like we've got one starting right back here.
So, somewhat related to what you were just talking about, so many news organizations are corporations now, and it seems like so many of them have bent the knee to this administration, and everything you just said is great that we can defend the First Amendment, but when they're not defending the First Amendment, I mean, how do we hold them accountable?
Well, you know, obviously you can choose where you consume your news, and you speak with your decisions, your voice, you vote with your feet. You can migrate to other platforms. We've been doing that for generations, right? You know, we make the decisions as consumers. You can always write about your opinions about what a particular company has decided to do, you know, but at the end of the day, we don't, you don't, I don't control the decision and the paths of companies. They respond, or for public companies, they're supposed to respond to what they deem the best interest of their shareholders. I'm not defending the decisions that have been made. I am saying that our real power here is to speak and to consume and to read. If you don't like the product, you don't like the way management has made decisions about the direction or who they're selling to or who they're buying from, don't listen to them anymore. And if enough people make the decision, like-minded people make that decision to do that, maybe something will change. It's a lot like who's in public office. You know, you really can't make that decision on your own. It has to be concerted activity, and you just have to use your voice.
Can you wait for a microphone, please? Yeah, can you wait for a microphone to reach you just so, yeah, it's okay.
Hello, and thank you. I think so often, every day, I contemplate, we're talking about human rights, the ability, transparency, to be involved, know what's going on at many different levels. We're faced with putting people in lockup, thousands of people. And where are we? We're just sitting in the public. We don't know what's really going on. We can't firsthand observe. And ICE has privateers running these operations. Where are we in this country with regard to this next step? It could be me, it can be you that's locked up. You know, we've watched it around the world. We've watched it historically. So where are we when it comes to reporting, really getting information back into communities?
I actually think the press has done an excellent job covering the, to pick Minneapolis or Los Angeles, take your pick. I think that it has been front page news every day. I think it also took, unfortunately, the murder of two people exercising their First Amendment rights, Alex Priddy and Renee Good, to wake people up. But we are seeing a change in policy, at least in Minneapolis, a pullback. And I don't think that would have happened without the conspicuous and continuous coverage of the American press. That was my message here today, is that we really all need to do what we can to support our local and national journalists to make sure that they keep doing what they're doing. Because if they all go away, then I think there is no solution, there is no pushback. But I actually think the press has been doing a very good job, and as I said, I'm proud of the work that media lawyers are doing to try and support their efforts. But I do share, as an American citizen, your concerns for the massive lockup and deportation of people without due process.
Else? Thanks to our mic runners. It's a hard job when there's no center aisle.
Thank you for appearing here and giving this talk to us. Did on the defamation case, like that 60 Minutes was sued by Trump, was that a personal suit that he filed against 60 Minutes and CBS? And did he receive the cash or whatever? If they paid him to settle that, did he put that in his pocket? Is that where?
I can tell you I know he was the plaintiff in the lawsuit. I do not know whether he received money personally, and I was not involved in the lawsuit. I'll also tell you CBS is a client of my firm's. I did not handle that case, and so even if I did, I would have to be very circumspect in what I would say about it.
So the public, we're never going to know the result of that?
No, I think, with respect, I think the information is out there. I think you should go look for the information. It was largely reported on what happened in the case, what President Trump alleged, what CBS said in making the decision to end that case.
I just wondered if Trump is personally pocketing, like say, the money, anything that's awarded from those.
My understanding of the terms of the settlements, and I'm not positive because I was not involved, but my understanding of the terms of the settlements with President Trump were donations to his library fund and paying a fee to his lawyers. That's my understanding of what those terms were. And so you can read into it what you will, make of it what you will, disagree with it and rail out about it, but I think those are the facts.
And meanwhile, was it Jean Carroll that won a suit against, the defamation suit against him?
E. Jean Carroll, yes.
E. Jean Carroll. Has she received anything in return for that?
I don't know. I know she won, and I believe it was upheld on appeal. I wasn't involved in that case as well. Whether he's actually forked over the jury award to her, I do not know.
Sure. Thank you. My question is, the legacy media, it seems to be, there's a lot of mistrust, especially with our younger generation, and there's been the advent and the rise of independent media, especially with social media. How does an independent journalist protect themselves if they find themselves in these types of situations that, given, Don Lemons is a quote-unquote now an independent media. How do they find this type of protections for themselves and getting an attorney to help represent them?
I'm going to give you a website, rcfp.org, Reporters Committee for Freedom of the Press, very familiar organization to a number of people here. They will, if you call them as an independent journalist, they will find you or at least help you or at least steer you in the right direction toward finding counsel. And there were a number of law firms in Washington, D.C. that actually have cropped up recently in order to assist anybody who is adverse to the Trump administration for violation of their civil liberties. And so there is information out there for you, for the independent journalists. I would also suggest that you look into, if you have a regular presence on the web of some kind or another as a journalist, you look into insurance, not for the arrest situation, but for the chilling defamation lawsuit that you may draw. As I said, that's a very essential tool in your toolkit.
I think we've got time for two more. So if you've been hesitant, now's the time to stop being hesitant.
Thank you. I was just wondering what you thought about this. I was surprised and dismayed to read in the New York Times, I think it was last week, that the newly elected mayor of New York, he did a press conference and he didn't invite certain legacy media papers around New York City and really emphasized, I think, younger people doing probably legit journalism. But it seems sort of this kind of wave of people kind of curating who can come to their press conferences. And I don't think anybody was necessarily barred, and the New York Times did report it, so clearly the information got out. But I just wondered what your thoughts were with that it seems people feel free to sort of say, hey, you can come, but you can't to press conferences.
I actually don't know the details on Mayor Mondami's decision, so I'm not going to speak from a position of ignorance. I'll take it a little larger. Regardless of your political party or your point of view, regardless of whether you're the mayor, the sheriff, or the President of the United States, it is unconstitutional and a violation of the First Amendment to exclude people when everybody else is invited simply because of your point of view in a structure where traditionally everybody has been invited. I had a very interesting discussion in the Associated Press case with the courts about, is it a constitutional violation for the president to have a one-on-one interview with Fox News and nobody else? And I said, of course not. Everybody has a favorite or favorites, and you can invite one or two in. It's when you have an established system like the press pool in which you directly tell the AP that you must leave because we do not like the way you report the news. That gets my First Amendment hackles up.
One more? All right.
First of all, thank you so much for this presentation this evening. I was wondering if you are concerned, or if your firm is concerned with the recent Paramount Skydance, which we think is going to now win the Warner Brothers contract, and representing a huge multimedia conglomerate. But with CNN, if there is concern that CNN is going to be peeled out and sold, and to who that may happen, what your concerns may be.
And I'm afraid to say that because both Paramount, CBS, and CNN are deeply beloved clients of my firm, and we vigorously defend both of their rights to gather the news, that I really can't respond to your question, and I just wish the entire ecosystem of journalism well in finding the right path.
Okay, well, I think we have one other item of business here, Dean Yoon, do we not? But I'll take the moment, of course, to also thank Chuck one last time before I leave the stage. And I should say, of course, my thanks and gratitude to the Lerude family as well.
Thank you, Chuck and Patrick, Mr. Tobin, and Professor File. Thank you very much.
Thank you.
Thank you.
Thank you. Appreciate it. Honored to be here.
Oh, out of all these events, First Amendment is always beating my heart. Like every time I come and talk about First Amendment, this is why I love my job, and thank you for coming today. Tonight, we have one more, the order of the event, that we will have Janet and Warren's son, Eric Lerude, come up stage, and we will present the First Amendment lecture plaque to Mr. Tobin. Yep.
I missed the memo.
But before we get to that, more thank yous. Thank you, Dean Yoon. On behalf of my parents, Warren and Janet, and my sister and her husband, Dan, and my wife, Stephanie, it is our privilege to say thank you to you for visiting us in Reno for this special event and for your thoughtful comments this evening. We appreciate the perspective that you've shared. Thank you for the action items that you gave us to take with us. Many people worry a lot and don't know what to do, and action items are a good thing to help us through this time. Your clients are very lucky to have you on their side. You're a fierce advocate for the First Amendment, and we will be watching, we'll be cheering for you, so thank you. I also want to thank Patrick, Professor File, wherever you went to, for your insightful questions and comments tonight. That was a fabulous forum that's part of this event, along with the lecture, the forum. So thank you, Patrick. Thanks to all of you in the audience for attending and for participating, asking a lot of good questions. I also want to take a moment to acknowledge and thank, there's quite a few people who've been involved in helping put this second annual Lerude First Amendment Distinguished Lecturer Forum together. Dean Yoon for your leadership, Professor File, Professor Caesar Andrews, who knows Chuck, and as you mentioned, reached out to Chuck, and that is why Chuck is our speaker, so we're very lucky. Thank you, Caesar, for speaking up about Chuck. Thanks to Professor Kyle Stanley, who's also part of our committee. I also want to thank Development Director Carol McIntosh, as well as others, including Barbara Traynor, Kathy Whalen, Leela Reeves-Hampton, Sharaba Chala, and Richie Bednarski. We appreciate all your efforts. This couldn't have happened without all of you making such contributions. So thank you. I also want to take this moment before I present a special award to Chuck. I want to say a few words about my parents, Warren and Janet. It is because of my parents that we are here tonight. I did this last year. Throughout my dad's long and distinguished career, first as a journalist, then as a journalism professor, and I have to say, most recently, as a concerned citizen writing op-ed pieces on journalism-related current events, which we've all been happy to see and read. The First Amendment has always been his ultimate guiding principle, because the First Amendment has had such a significant impact on both of my parents, and because of their love of the Reynolds School of Journalism and their long-standing commitment to this school, they wanted to create this event. They wanted to acknowledge the importance of a free and independent press and to further the J School's mission in First Amendment education, not only for the students here at this school, but also for the university community as a whole and the general public. We are grateful that my parents are here tonight for the second year of this program that bears our family name. So let's please give them a well-deserved, incredible applause. And now, finally, on behalf of my family, it is my privilege to present to Mr. Tobin the Lerude First Amendment Distinguished Lecturer Award. Thank you. I'm proud to display. Thank you. And with that, I think we're done. Yes. I'll let you.
Yeah, no, absolutely. As I said, it's just been an app. If you haven't seen it, this is lovely. I look forward to proudly displaying it on my shelf. It's a wonderful memento for a wonderful 48 hours with all of you. I look forward to continuing the engagement and the discussion. And if I've inspired some good kind of trouble out of this audience, then I've accomplished my goal. So thank you all very much.
This brings our 2026 Lerude First Amendment Distinguished Lecturer Forum to a close. Thank you, Lerude family, for their support in making this event possible. And last message I would like to tell you, we worry about CNN and Warner Brothers, but the real message here is support local journalism. Thank you.